My name is Chris Bachmeyer. I'm part of the panel. I'm going to talk to you today about speedy trial rights. As a judge, put yourself in this situation. You start your first day in a criminal docket rotation, and there's a jury trial on the docket. You look at the case and note that it's over a year old. The defendant has been sent down for a competency evaluation, but the trial has now been reset several times at the request of both parties. After you call the case, the defense attorney stands and requests a dismissal based on a violation of his client's speedy trial rights. What do you do? The right to speedy trial has both a constitutional and a statutory basis. The constitutional right begins at the filing of charges or arrests, whichever's first. The statutory right, which is the most common basis, is triggered when the defendant enters a plea of not guilty. The statute, CRS 18-1-405, has subsections addressing the time computations under two main categories. First, the period of time that are excluded from or told the running of the statute, and secondly, time periods that extend the initial 6-month period. The 6-month period begins to run from the date the defendant enters a plea of not guilty. If the case is not brought to trial within 6 months from that date, the case must be dismissed with prejudice, unless, first, the defendant has waived the right to a speedy trial, or the 6-month period has been extended as provided by the statute, or the running of the 6-month period has been told by an event which causes the intervening time to be excluded. The defendant has a burden to show a violation of speedy trial rights prior to trial or entering a guilty plea. The defendant need only assert the case was not brought to trial within the time limit specified by 18-1-405, regardless of prejudice. If the defendant does so, the case may be dismissed. To avoid dismissal, the prosecution must show the statutory speedy trial time period was somehow properly extended or told under the statute. If charges are dismissed for lack of speedy trial, the defendant may not be re-prosecuted or charged with another offense based upon the same act or series of acts arising out of the same criminal episode. The prosecution and the trial court are responsible for ensuring compliance with the speedy trial statute. There's no obligation on the defendant to notify the court of any speedy trial problems. The defendant must, however, assert his violation of statutory speedy trial rights prior to trial or entry of a plea of guilty, or the violation is deemed to be waived. Finally, the trial judge loses their jurisdiction if speedy trial has been violated, and the case shall be dismissed. So what should you do as a trial judge? First, be cognizant of speedy trial dates in every case and at each hearing. Take the time to mark in the file the specific date and event that triggers speedy trial. Ask the attorneys to affirm on the record the date which trial must commence. Be careful about who is requesting a continuance of a trial in order to determine if a waiver is necessary. Second, if there is a waiver of speedy trial, ask the defendant specific questions to show he has an intelligent, knowing, and voluntary waiver of speedy trial. I inform the defendant why his attorney is asking for a waiver, and then I ask specific questions such as, have you spoken to your lawyer about your right to a speedy trial? Do you understand this court has 6 months to set a trial from today if you waive your right? Has anyone forced or coerced you to waive your right to speedy trial? Are you asking the court to waive your right to speedy trial today for the reasons your attorney placed on the record? The third pitfall is tolling speedy trial in cases where mental health is a defense. It is critical to have the number of days placed in the record when mental health issues are raised and the defendant is sent for an evaluation. When the defendant is back in court, determine the number of days left on speedy trial. And again, ask the prosecution and defense to verify your numbers. Speedy trial is also commonly implicated in jury mistrials. The court has up to 3 months to exclude speedy trial calculations in order to commence a new trial. Other common occurrences are defense failure to accept trial dates within speedy trial, good cause by the prosecution to set outside speedy trial, and interlocutory appeals. In each of these situations, make clear and complete record of all facts regarding the court's calendar, the efforts to set the trial, the prosecution's efforts to get the trial set within speedy trial, and all other issues that pertain to your decision to extend or toll the defendant's right to speedy trial. At the end of this presentation, there's an example of a written waiver. It'll be attached to this presentation. Thank you.